Alrighty, then I'm going to get started. Thank you everyone for joining us today. You're all here to learn a new legal skill, and Houston Volunteer Lawyers is happy to be a part of bringing that to you. Houston Volunteer Lawyers is a nonprofit part of the Houston Bar Association, and we provide free legal services to the low-income people in Harris County. A large part of how we do that is by connecting with private attorneys and getting them to volunteer and take cases. So the intention behind offering a CLE like this is to have you all learn about a new legal issue and then be able to take those cases with us moving forward. And a new project that we started in December is the New Attorney Pro Bono Project. It's something that we're able to do with the help of the Houston Young Lawyers Foundation. And what we're doing is we're providing CLEs to newly licensed attorneys. These are practical CLEs on issues that we take at HVL so that you can get started building your pro bono practice early on in your careers. And if you missed the inaugural event that we had in December and you want to find out about it, we can send out that information after this presentation. So the team here at HVL who have put all of this together are myself, but this CLE especially came together with the work of Brittany Mandarino, who is a staff attorney at HVL and has a pro bono fellowship from the Association of Women Attorneys. And then our team leader is Veronica Jacobs, who is the Director of Advocacy and Community Services at HVL. And so today we are going to be learning about expunctions and non-disclosures for indigent clients. This is clearing criminal records. And to teach you today is Naomi Howard of Rusty Harden and Associates. And with that, Naomi, I'll let you switch the screens and take it away.
Thank you, Henry. So today we're going to be talking about expunctions and non-disclosures. The title of this CLE is When is an Arrest a Life Sentence? This is not about exonerations or getting better plea deals for your clients. It's about what to do after you think the case is over, because most of us think that when you have a case dismissed, or if you get deferred adjudication and your client completes that successfully, then your case is over, right? Book is closed, you're done. And that could be the case, that you are done, but then hopefully an attorney like me can come in and help with getting your client's record cleaned up. What I really hope is that after listening to this CLE, a lot of you will take some pro bono cases and help clients of Houston Volunteer Lawyers to get their records cleared up. And so I'm going to tell you a little bit about who I am. Let's see. This is who I am, and the picture of me in the suit is what the website at Rusty Harden and Associates shows. Clearly that is professionally done. The picture with the mask on is how I'm usually looking these days. In fact, a lot of you are probably working from home today as well. So it's not all glamour over here at Rusty Harden and Associates. And for those of you who don't know, this picture in the middle, this is my boss, Rusty Harden. And if you don't know, he's a huge Rockets fan. And so we like to go to the Rockets games, and COVID has really put a crimp in that. but let's get started today. And like any good book, we're going to have a table of contents. This is just kind of to give you an overview of the overview that we're going to do today. So we've got what's the difference? Well, you guys can read. We're going to go over what is an expunction, what is a non-disclosure, and then, you know, think about why you need to be thinking about it from the beginning if you ever handle criminal defense cases. Then go into the nuts and bolts of each. And we're going to have you get some ethics CLE credit today. So we're going to do a little bit of ethics. And then finally, we're going to talk about the internet and how it foils all our good work on expunctions and non-disclosures. So first off, what is the difference between an expunction and a non-disclosure? First of all, non-disclosures are, if you've heard the word sealing a record, that's what a non-disclosure is. It is a civil petition, but it stays in the court that the case was originally in. So it's done in criminal court, but it's a civil procedure. And so you're going to file it in the criminal court that originally had the case. I like to think of non-disclosures, sealing records as kind of like password protecting your client's criminal record. It doesn't mean that some people can't see it. Law enforcement is going to see it. Different agencies are going to be able to see it, but the general public is not going to be able to see it. So that's why I kind of like to think of it as password protection. On the other hand, expunctions are filed in civil district court, and they are a completely civil animal. They're separate and apart. They will get a different cause number than the original criminal case. And it's like throwing things in the trash. It's hitting the delete button. So it is obviously a much better resolution for your client, but the eligibility for an expunction is very difficult. You have to get a dismissal, and we're going to go into the details of eligibility, but generally speaking, you have to get some sort of dismissal, whether that is from a pretrial diversion program or from a straight out dismissal. And I'll talk about that a little bit more when we get into expunction. Some of you may not know what pretrial diversion is, and so I'll give you kind of a quick down and dirty. Non-disclosures have really broadened over the last decade or so. You used to not be able to get a non-disclosure or to seal a DWI if you got a conviction or probation. And in 2017, the legislature allowed people to get those sealed on their record, realizing that a lot of people get DWIs, and because you can't get a deferred adjudication, that meant that under the current law, you couldn't get a non-disclosure. And so they've opened that up. You can even get a non-disclosure for some misdemeanor convictions. But again, very narrow, and we're going to go into that a little bit later. Okay, so why are we concerned with cleaning up our clients' records? Well, the main reason is that even though your client has served his or her debt to society, their criminal record, even an arrest, can follow them for a lifetime. Thus, the title of our CLE today, when is an arrest a life sentence? Because even an arrest can follow you around, but certainly if you get deferred adjudication, that is like a probation, and then if you successfully complete it, you get a dismissal, but it's not a true dismissal. And so those will stay on your client's record, and those records are available publicly on the district clerk's website. So you want to be able to clean up your client's record for housing, whether you're renting or getting a mortgage. You want to do it for employment reasons, because just to get hired, having a record, even an arrest or a dismissal, can prevent you from getting hired. It can also prevent you from getting a promotion. I have clients who say that, you know, oh, they're really worried that this arrest is going to be on their record and they're up for promotion, but that promotion requires a background check. And then there are a myriad of collateral consequences, but one that people don't think about is dating. I imagine, although not necessarily, more women are doing criminal background checks on men that they're dating online, just to be safe. And certainly an arrest or a dismissal or a deferred adjudication, that can be a red flag. And so that might prevent you from dating. But there are many reasons, and it's just that these things follow your client around, and it's amazing the prejudice that people, myself included, you know, when we see a criminal record, it's a yellow flag at the very least. So you need to be thinking, if you're a criminal defense lawyer, and I know that most of you are not criminal defense lawyers. You're probably just looking to help out and be a volunteer lawyer, and that is fantastic. You don't need to worry about this, but just for you to know, maybe you've got a family member or a friend who gets arrested or has something. A lawyer really needs to be thinking about expunctions and non-disclosures from the very beginning of the case. It really is thinking 10 steps ahead in your case, because hopefully you're going to get a dismissal, right? Like that's what we're hoping. And if you get a dismissal, then you can get your case expunged. But it's important to know that expunctions are arrest-based. What has happened frequently for my clients is they will get like a public intoxication charge, and then they will get an assault charge, say, or more often than not, a DWI and a unlawful carry of weapon. And so because expunctions are arrest-based, if you plead guilty to one of those, then you cannot get an expunction. You have to have all of the charges that spring from that one offense, that one arrest. They all have to be dismissed in order to get an expunction. We're not going to talk about juveniles today. That involves the family code, and that's too much. That's more waterfront than we want to cover today. And then I also want to talk about non-disclosures. You have to think about those, not just whether or not to plead your client to a deferred adjudication, which again is just like probation, but you get your charge discharged or dismissed at the end of successful completion. But things to look out for are, these things cannot be sealed. So if your client has to register as a sex offender, if they're guilty of injury to a child, the elderly or the disabled, stalking is a very common one. You only have to post twice on Facebook, and it annoys, alarms, or bothers somebody, and you could be guilty of felony stalking. So, and you wouldn't think that can't be sealed, but it cannot. And then these sneaky affirmative findings of family violence. you know, if you've got an assault charge, you've got to get that affirmative finding of family violence somehow reduced, taken away, because it's going to it's going to affect what you're able to do afterwards. Okay, so let's see. Now we're going to talk about expunctions, and this is, you're going to be filing a petition to expunge a criminal record. So you need to go to Chapter 55 of the Texas Code of Criminal Procedure. And this is where you will find all of those, the statutes that you need to deal with an expunction. And I'll remind you again that you have to, it has to be, you know, all the charges from one arrest have to be dismissed. And this is where I come to my first kind of piece of advice is, you know, as Ronald Reagan says, trust but verify. That means you want to talk to your client about the case, and you trust your client about what happened, you know, did they get the case dismissed? But you have to verify that with the pleadings. And so you need to make sure, don't go, you know, don't think you can file an expunction petition and just do it based off of what your client tells you. You have to get the documents from the clerk's office if your client doesn't have a copy of those. So most of the time you can go to an attorney portal if you need those documents. I know Brazoria County, Montgomery County, Travis County, they all have attorney portals, which you have to sign up for because they're not allowing these documents to just be downloaded by the general public. So you need to download that, and that's mostly free. There will be times where you may have to pay. Those are usually smaller rural jurisdictions. So Class C are misdemeanor offenses, and they are the only ones that you can get a deferred adjudication for and still get it expunged. So everything else has to be a dismissal, but if you get a Class C and you get deferred adjudication on that, then you can get that expunged. You need to also be aware, I know we said we weren't going to deal with juveniles, but something that comes up a lot, I haven't had a tobacco use, but an alcohol involved offense. So those fall under the Texas Alcoholic Beverage Code, and they have special rules and special expunction rules for juveniles. And the only reason I go over this is because this, you know, minors in possession happen all the time. So it is kind of good to know that if you go to the Alcoholic Beverage Code, you will find your own set of rules for those expunctions. The thing that I see that people, and myself included when I first started doing these, is people get tripped up on the waiting period language of 55.01. And it has like 180 days and different, you know, waiting periods there at the beginning. That is only if an indictment or an information is not presented. Presented means given to the judge. And I just want to make sure that everybody understands an indictment is something handed down by a grand jury in felony cases, and an information does not need a grand jury, and it's for misdemeanor offenses. Let's see. Unofficial deals, like I had one client get, it's called BIP, Batterers Intervention and Prevention Program. This is technically a parole program for someone who has been discharged from custody after a conviction, but It is basically an anger management / family violence program. And I've had a prosecutor say, look, if you'll just have your client complete this BIP program, we'll call it a day and I'll dismiss it. And that is great for the client, but something to be aware of is that prosecutors in the courtroom who are dealing with the criminal case are not always the same prosecutors who are dealing, in fact, often are not the same prosecutors who are making the decision on the expunction. So this BIP program, as I said, it's a parole program. It does not fall under Government Code 76.011. That's Government Code 76.011. And that code covers pretrial diversion programs. And I told you that pretrial diversion programs were, that I'd explain that later. And that is a program that is a lot like probation. You have classes to attend, you have to check in with the community supervision department, you have fines to pay. But the great thing about pretrial diversion is that you get your case dismissed if you complete it successfully. So that is awesome. And the Criminal Code of Procedure, Chapter 55, takes these pretrial diversion programs into account. And that's all Government Code 76.011 is an officially sanctioned pretrial diversion program. So if you don't have a pretrial diversion and your prosecutor gives you another option, you may have to do either a discretionary, because the state's attorney, the prosecutor, has discretionary power to agree to an expunction, but otherwise you have to wait till the end of the statute of limitations, because theoretically the prosecutor could refile a case. And so that's 2 years for misdemeanors, 5 years for felonies, which is a bummer. But if you let your client know in advance that this is what we're going to be dealing with, that the prosecutor won't agree to a discretionary one, you're going to have to wait 2 years, is that okay? Then you should be fine. But you always have to let your client be prepared if there's a waiting period. Speaking of pretrial diversion programs, sometimes, so this is an agreement between your client and the prosecutor's office. It really has nothing to do with the court or the judge. It is completely at the discretion of the prosecutor. And so it's basically a contract. And in that contract, sometimes the prosecutor will say, you can't apply for an expunction before 2 years are up. And unfortunately, we defense lawyers don't have a lot of leverage on this. So we're kind of stuck with that. And we can't, that's just, we have to deal with that. And again, if your client's signing this pretrial diversion agreement, they should be aware, just point it out to them. You want to manage your client's expectations. So pretrial diversion agreements, they also can contain a waiver of expunction for the DA's office and for community supervision. And this is so, I've seen this happen in family violence cases a lot. They want to make sure that they are aware of any prior family violence incidents. Because true abusers often repeat the abuse. And so they don't want that to completely disappear, because if something happens in the next 5 years, they want to be able to prosecute that. And so there will be a waiver. And again, there's not much you can do with that. You can ask, always ask, but often pretrial diversion is such a great deal that you're not going to have much choice. Let's see. So I think the next thing is your respondents. And, oh, sorry, I skipped something there. Petition. Sorry, guys. Your petition needs to, you again need to have your court documents. The reason this is important is because you want to check all the documents. If you've got an offense report, that's really good. That's not going to be available on the clerk's website. That's usually going to be with the lawyer who did the case. And if you can get that from the lawyer, that is the best thing you can do, because then, and they can't share it with the client, by the way, because of Michael Morton. Discovery is not shared with clients in the sense that they're not given copies. They can view them in an attorney's office, but they can't take home a copy. So it's ideal to get an offense report, not absolutely necessary, but if you can get it, that's good. And here's the reason why. Because I have had times where the court document will have one number for the incident number. That's what the police use. And the offense report will have a different number. And so you've got the court reporting that the police identify your client's record by one number, but the police actually are identifying your client's case by another number. And you just put both of them in there. You say where you found them, and you just put both of them in there. And I've had that happen with a client's race, address. Addresses often get wrong. And the reason why you want to list all those things, even though they're incorrect. Oh, and by the way, if everybody's incorrect, like on an address or a race, be sure to put a line about this is the correct race. This is the correct address. So that if somewhere there is hiding the correct address, that will be there. And again, like I said, the reason why you want to have all of this identifying information for both your client and the offense is because you want all of the agencies to be able to identify all of their records and to delete all of those records. The petition, after you've finished it, you want to have your client review. Can't tell you how many times, you'll be one digit off on a social security number, a driver's license number. And so hopefully your client is reviewing with an eye towards detail, and will help you catch those mistakes. And then also you need to review it just because you don't want to file any pleading that your client hasn't reviewed and that you haven't gone over with your client. There is a verification to every expunction petition that needs to get notarized and signed. During COVID, that can be challenging, so be aware of that. You may have to help your client find a place to get the verification signed and notarized, so just be prepared for that. Let's see. Oh, I like to put at the top of my petition a little kind of office use only block where the clerk can set a time and date for your show cause hearing. And so that you will not fill in a cause number. You will not fill in the court on your petition. That is all assigned by the clerk's office. So that you want to leave those blank as far as the court and the cause number. And then I find it's really nice to have like a little gray box or something that kind of sticks out for the clerk that they can set a show cause hearing. Some jurisdictions ask you to submit a proposed order as well. And sometimes you don't. Montgomery County, they want you to file your own proposed order, but Harris County, they've got no use for your proposed order. They're going to send you their own, hopefully agreed order, and they don't need your proposed order. In your expunction petition, this keeps jumping. These are your list of respondents that you usually have. You're always going to want to put the district clerk, but in some counties, not Harris County, but in some counties, they're like Brazoria County, the county clerk handles misdemeanors and the district clerk handles felonies. You always have to put the district clerk because, as I said, it's a civil filing and a civil district clerk and a civil district court. But if it's a misdemeanor, the county clerk will also have had documents, had pleadings, have records on your client. And so you need to make sure to include the county clerk in your list of respondents. And by the way, your list of respondents is just everybody you need to notify that your client wants an expunction. And then when you have an order, these are all the people who are going to be ordered to delete those records. So a lot of it is common sense. You just think of, okay, who could my client possibly had contact with? And though that's your list. But this list right here is generally everybody you need to include. You'll see that DPS is one, and you're like, wait a minute, that's a state agency. How does a Harris County District Court judge have jurisdiction over DPS? Well, that's by statute. So DPS has to follow the orders of the court. And then you'll see this one, OCA. And by the way, DPS is Department of Public Safety. I mean, I think we all know that, but you know, it is an acronym, so don't want to confuse anybody. OCA, that is the Office of Court Administration. That is a new required respondent. And if you didn't know, OCA is in Austin, and they are responsible for the, if you go to the different appellate courts and their websites are administered by OCA, the OCA gives guidance to district courts, county courts at law. They basically, any court in Texas has some sort of contact with OCA. And the reason why they are now requiring OCA to be included is because now a lot of, well, all counties, I believe, are now uploading to the, I forget what the database is, but it's like research with a colon between the RE and search. And because these documents are making their way into the database that OCA maintains, you need to let them know so that they are also deleting their records. Private entities, this could be like mugshots.com. This could be a mylife.com, anything like if your client's records are ending up on some website, it's helpful to include them in the order so that they are ordered by DPS to, and DPS is the entity that would take care of that notification, to expunge that record, to delete that record, because I'm not sure if you're aware of it, but law enforcement around the state sell arrest information, mugshots, and so those can get distributed over the internet to different private entities, data brokers. And so if you know already prior to filing the petition that your client's criminal record is showing up then you should include them in the petition. School districts, a lot of people, I know, again, we said we're not going to talk about minors or juveniles, but for example, a university student or an 18-year-old in high school, the school district is going to have records oftentimes, because by law, and this is something to know if you have a student client, is that when they are arrested, that information is, by statute, should be shared from law enforcement to the school so that they can protect the students. Okay. After the expunction order, you're not done. You have to allow the district clerk to comply with the order. You have to let all the respondents, give them time. What is interesting is that there's no statutory deadline for the agencies, the respondents. Only the district clerk has a deadline, and that's 1 year. And so it's implied that everybody else has 1 year, but it can take up to 1 year. I've found Harris County is much faster, but just make your client aware that it can still be showing up even up to a year. If you have a client that is not a citizen, please, please, please get certified copies of things like the charging instrument, which is that indictment or the information, the order of disposition, which is like the dismissal, and then also the order of expunction. And the reason is that once those records are gone, they are gone. And if 2 years after the expunction, your client applies for citizenship, then they're going to ask, even though, it's supposed to be deleted and you can tell people that it never happened, except if you're in criminal court, it's still probably safest to tell ICE that it happened and that it was expunged. And I say safest, that is really, that's beyond my purview. That is for your client to discuss with an immigration attorney. My job as the attorney getting the expunction is to make sure that the client has everything he or she needs in case that comes up. And so that's why I say get certified copies of those particular records, the charging instrument, the order of disposition, and the expunction order. Okay, so finally, the best part of all this is that immediately after the order of expunction is signed, your client can say that they have never been arrested. They can just deny it ever happened and they don't know anything about it. The one exception is if they are on the stand in a criminal proceeding, then they have to admit that the arrest happened, but all they have to say about it is that it was expunged. So that is fantastic. Okay, going too fast again. Non-disclosures. Again, this is a civil proceeding, and but it's filed in the criminal court that that the case originated. And sorry, you guys, I'm going to go back one slide. The expunctions. The expunction petition, occasionally you will have a Class C. This is actually not occasionally, but you often have Class Cs, especially with indigent clients. And those can be filed in municipal or JP. So in Chapter 55, there is special jurisdiction for municipal and Justice of the Peace courts. And that is going to be significantly less expensive for your client. I don't know a lot about getting waivers for fees. Houston Volunteer Lawyers can probably help you out with that part. But if your client is having to pay the fee, knowing that you can file in municipal court or JP court can be a lifesaver. So, all right, let's see if we can get back to where we are. No, non-disclosures. Okay, so I know we're running short on time, and frankly, I'm a little bit glad with non-disclosures because eligibility for a non-disclosure is a little bit like doing a tax return, or if you've ever been in federal court on a criminal matter, doing the sentencing guidelines, because you have to go over, and it's chapter 411 of the Texas Government Code, you have to go over the eligibility under that chapter with a fine-tooth comb. I still will get things wrong. So you should look very carefully at how your client's case was disposed, and then check the code for which statute of eligibility it falls under. There are generally 8 categories, as you can see here. Because we are running short on time, I'm not going to go over those 8 categories in depth. And like I said, you need to figure out which one of these applies to you and then go read the statute carefully. Section 411.074 is the required conditions for all non-disclosures. And this A part, no conviction or deferred adjudication for another offense from the time sentenced to the time the sentence is complete, plus the waiting period, again, misdemeanors 2 years, felonies 5 years. This can be tricky when pleading as well. Sometimes your client will pick up 2 cases, but yay, you've negotiated deferred adjudication on both of them. Now, it is unlikely that you will plead to those 2 and get sentenced, that you will not get sentenced on the same day for those, but on the off chance, like you're still negotiating on one and you just want to go ahead and get this other one out of the way, please, please, please do not. Because it is going to be disastrous for your client, because they're not going to be able to get a non-disclosure. Because as you can see, while they're doing the deferred adjudication for the charge, they can't get a new charge. They can't get a new sentence after that sentencing on the first one happens. So that's another thing to look closely at, especially if you're dealing with indigent clients. Sometimes they have multiple things going on. And so you really want to be careful on the timing before you advise them and get their hopes up that they're going to get it. And again, as we talked about in the beginning about your trial strategy, if you've got sex offender registration or any sentence with an affirmative finding of violence, you are going to be out of luck. The non-disclosure petition is actually a lot easier because you don't have to worry about a verification. So you don't have to get that signed and notarized. Definitely review it with your client as you would with an expunction, but there are not as many moving parts. You will also not have the respondents, the agencies that your client has had contact with in the petition. Those will go in the order, and you should file a proposed order with your petition. So you'll want to file that either as an attachment or as a separate document. And this is a good time for me to remind you guys that when e-filing these documents, there are a lot of local rules in different jurisdictions. And unfortunately, I'm super spoiled here and I don't do the filing. My absolutely wonderful assistant, Sandra Dominguez, does that. She is a pro. So if you get into any problems, I'm going to give you my contact information at the end. She and I can usually figure out how you need to e-file it. So again, you want to have your client review it, make sure that all the identifying information is correct. The clerk does not, you don't have a show cause hearing, and I know I didn't go over a show cause hearing before, and I apologize for the expunctions. Time is just running out. The show cause hearing usually doesn't happen. Usually there's an agreed order with the prosecution and you pass the hearing. With the non-disclosure, there is no show cause hearing, but usually the state has about 45 days in which to file something if they have objections, and they're the only ones that can object. The judge can deny it, the prosecution can object to it, but none of the agencies, once the judge has filed the order, none of them get that time period to object. DPS is a particular, with expunctions, they're never going to sign off. The other agencies will sign off, and usually the district attorney signs off for DPS. But if you freak out that DPS is not signing your expunction order, please don't. They never do it. Not for me, not for anybody. So, and I apologize for jumping back and forth. Anyway, proposed order will list all of your respondents. You will need to get a hearing set. You will call the coordinator of that court and get the motion set for a hearing. Let's see. After that, both with non-disclosures and with expunctions, there will be times where the hearing time has passed, there was no hearing, and everybody agrees, and you just need to get the judge to sign either the expunction order or the non-disclosure order. Give the judge a little time, especially with COVID, but call the coordinator after a month, and that usually will bring it back to their attention. These again, and hopefully if you want these slides today, I'm going to, you can email me and I'm happy to send them to you, or HVL may make them available, but it's basically the same. Whoever your client came in contact with, that's who you need to put as a respondent or as a agency who is required to seal. Under statute, the clerk has 30 days to seal the record. DPS, I think, has 15. Exemptions, okay, so there is a long list. And if you go to government code for chapter 411, they will tell you every single agency that is exempted from this sealing order. So attorneys, the Board of Law Examiners, schools, because obviously they don't want to hire people with criminal records, doctors, nurses, anybody who is getting licensed to do like broker work, like securities exchange, and hazardous materials related. Guess we don't want people to do that either. After your client's record is sealed, the order of non-disclosure has been signed, your client can again deny the arrest, except in criminal proceedings. And then obviously, if you are applying to get your law license, your medical license, or to drive hazardous materials, they've got access to those records. So you want to advise your client not to say that they haven't ever been arrested to those entities. The easiest thing for me, because usually I handle my client's criminal case, is for my clients just to give me a call and, if they are doing any applications and check with me. But if you're doing this pro bono, that may be a little more difficult. So I would just give them, I would make a copy, of chapter 411, the entities that are exempted from sealing, and then they will know. For both the non-disclosure order and expunctions, there are civil penalties for private entities that fail to comply. This is, in my mind, relatively toothless because the ones that are usually the worst are the biggest ones, like the credit reporting agencies. And frankly, after they get you have to file a petition with a court, so that's more legal fees. The court will give notice, and then it's $500 for each failure to seal or to expunge. And for these big multinational companies or for companies in the Bahamas, not really discouraging. Okay, very, very quickly, because I want to leave time for questions if we can. The internet is our worst enemy. There are mugshots.com, arrests.com, my life is the worst. All of these are private entities that buy information from, and booking photos mainly, from law enforcement agencies, and they have headquarters in the Bahamas. They're just really, they're not transparent about how to get a hold of them. And it's a scam. It's a scam that they have places that you can click on their websites, and they will clear your record, but that usually involves some kind of fee. It's just, it's extortion, if you ask me. Media companies like, because we have some high profile cases, and even, some of these, other cases, even small ones can make it into the news if there's, if it's interesting to the public for some reason. Human trafficking, prostitution, those are big ones. The Chronicle, the Houston Chronicle has kind of taken a position where they will no longer publish those things, and that's due to work by people like Carrie Blakinger and other journalists who have asked that the Chronicle and other media outlets get rid of things like mugshots. The ethics, oh my gosh, the ethics of expunging and sealing. Okay, so you are dealing with innocent or indigent clients, pardon me. You want to keep in mind that there is more going on in their lives than just their expunction petition or their non-disclosure petition. So you've got to kind of work with them, be patient. But also, on the other hand, you don't want these are really easy cases to let be on your back burner and forget about. And it's because there's no special urgency to them. The case is over. Most of the, with the reporting to community supervision, it's over. So it's real easy to lose track of these cases. And I would just ask you not to do that, to stay on top of it, put reminders in your calendar. Investigate eligibility before making promises to your client, A, that they're eligible at all, but B, on the timeline, like if you haven't seen the pretrial diversion agreement that your client signed, they may not be able to apply for that expunction for 2 years after they've completed pretrial diversion. COVID is causing a lot of delays in the court. So it's causing delays in the court, it's causing delays for communicating with your clients. So just be aware of that. Another issue that you should consider is, can you file a petition if your client isn't eligible? I would say that fortunately or unfortunately, expunctions and non-disclosures are very statutory in nature. I think I made the analogy of taxes earlier for non-disclosures, and that, you know, there's very little wiggle room. I told you with expunctions, the prosecutor has a lot of discretion, but as far as eligibility, you really just kind of have to go by the statute. And so you owe a duty of candor before the court. But you also have a duty of zealous advocacy. And so I would just ask you to keep those two things in mind when you're filing these cases. And you certainly want to think outside the box. But if you know your client isn't eligible, you absolutely don't want to misrepresent anything to the court in a petition or in a hearing. You know, and you can certainly see if a prosecutor will agree to something, but you do want to maintain that duty of candor. And so I think, oh, resources. Oh my gosh, this is so important. So Andrea Westerfeld is a prosecutor in Ellis County, and you can go to the Texas District and County Attorneys Association. Oh, I was memorizing it, and it's right there on the share screen for you. So yes, TDCAA, they have a website, they have publications. You can go there and get an edition of expunctions and non-disclosures. I cannot tell you how awesome it is. They even come with a CD, which seems so outdated to me, but they do have, or at least in past versions, I don't have the 2020, they have had a CD-ROM with templates, checklists, all sorts of good information. And I am such a geek about expunctions and non-disclosures that I have had Andrea Westerfeld sign my copy. And so a new copy comes out usually, I think, in the even years, because the legislature meets in the odd years. And so you'll want to, I almost hate to have you get a 2020 edition, but it'll be so long before the 2022 edition is out that if you're going to dive right in, and please do that, guys, that you should probably go ahead and purchase it. It's only $30, which isn't too outrageous. And so that's the main resource. The other resource is me. And here is my mobile number. Here is my address. You can call the office. It's listed on our website. I truly geek out over these expunctions and non-disclosures. I've done quite a few of them. I'm always happy to talk. And I have left us with no time, but I've got time, so I'm happy to stay and answer questions. I know that we have to, and Henry, you just jump in here if you need to cut me off. But
if you want, I can just, you know, people can hop off now, but I can read some of the questions we have in our chat and you can answer them.
I would love it.
Okay, great. And I'm going to just switch this screen sharing. We will share this PowerPoint so you can get Naomi's information if you haven't written it down yet. And I'm just going to put up our PowerPoint so you can see the CLE information. Can you see that?
I can.
Okay, great. Let me see now. How do I find the chat button? Okay, you know what? We've put the CLE in the chat. We're also going to be sending out an email, so you'll get it that way. And I'm just going to read some of these questions.
Okay.
Okay, so can a prosecutor agree to waive the waiting period for an expunction?
Yes, they can. They have a lot of discretion. Basically, what the court wants to do is make sure that the state doesn't want to refile charges. So if you can get so in Harris County, it's the General Litigation Division. If you can get those guys to agree, then you're good. or the appellate section in Montgomery County or one of the other counties. So yeah, they do have discretion on those.
Okay. And then if a client is charged with a felony, but then the charges are later reduced to a misdemeanor, how does that affect whether you're choosing an expunction or non-disclosure? Obviously, details will affect it too.
Right. I mean, I'm going to go ahead and tell you that's a non-disclosure, because the only way that, I mean, so if it was reduced and dismissed, but then why would they reduce it if, you know, if they're going to dismiss it? But they may, a lot of times I've had cases where a felony is reduced to a misdemeanor and then they get deferred adjudication. And so that, again, that's going to be a non-disclosure, and you're going to have to look at that case by case. Right. But it's going to be a non-disclosure.
Okay, and then another one we got: are bail bond companies exempt from expunging your record?
No, they are not. They are one of the private entities. So, you know, but that is a great question, because I don't usually include them, but they do have some of that information. I haven't had any experience where they've been selling the information, but yeah, you can include anybody you want. You can include me if you want. I don't have any, I'm going to come back to you and say, I don't have any information, which is, if you call DPS, they're going to sometimes tell you, especially with misdemeanors, it doesn't make it up through the chain to their database. We don't have anything. So you can put anybody you want on that list. But yeah, I haven't done a bail bonds company. That's a great idea. I say do it.
Okay.
Henry, are you?
I think you froze, or I froze.
One of us froze.
Did you hear my question at all?
No, I didn't. Yeah, if you could repeat that, that'd be awesome.
Deferred adjudication in a case where there's injury to a child. Can you receive expunction on that? No.
Well, wait a minute. So no, that's, well, you just said deferred adjudication. So that is not a dismissal from a pretrial diversion or a dismissal because of lack of probable cause. If they are dismissed, and again, I wish they would use a different word, maybe like discharged, then yeah, deferred adjudication, except for Class Cs, you have to go to the non-disclosure box. That is not an expunction.
Okay. I think that's good on questions. I mean, you really packed in all the information, and a lot of people have stuck around after the hour. So thank you for staying, everybody. I'm just gonna share now the CLE stuff one more time in case you want to write it down. But yeah, thank you. We will send out the PowerPoint. We'll have the video. And so you'll be able to get in touch with Naomi. You can get in touch with us here at HVL. And then hopefully you'll all sign up on our volunteer portal and start taking these cases now that you have a measure of expertise that a lot of your colleagues out there might not have.
And I hope, Henry, the Houston Volunteer Lawyers, we will do a, we will expand on this, and I would love to do a non-disclosure CLE, and maybe we can get even more into the geeky, nerdy stuff of, the details, and maybe even go over, if you take some cases, maybe we'll get you guys together virtually, and we can go over those petitions together. So, because I love this stuff. Idea.
Okay, well, with that, I think we're going to end it. Thank you, everybody. Thank you so much, Naomi. It was a pleasure having you, and I know I learned a lot. So thank you so much.
Thank you all for coming.
All right. Have a good weekend, everyone.